This is the examination of the hidden human condition.
You're listening to the Hidden Killers Podcast.
This is the Hidden Killers Podcast with Tony Brueski.
Neama Rahmani is joining us. He's president of the West Coast Trial Lawyers Association and a former federal prosecutor, discussing Bryan Kohberger and some of the newer developments in that case concerning the defense and the prosecution. Attorneys for Kohberger filing a motion seeking to get his indictment dismissed. They're arguing that the grand jury was misled as to the standard of proof required for an indictment. They say the grand jury should have been informed by the standard of proof required for an indictment would be beyond a reasonable doubt. However, they argue that the grand jury was instead erroneously instructed with the standard of proof required for a presentiment, which they say would mean having a reasonable ground for believing the defendant had committed an alleged offense. The failure to properly instruct the grand jury as to the standard of proof is grounds for dismissal of the indictment. That's what Ann Taylor is arguing to the court. Is there any legs to this? Is this a valid argument in this case?
Not at all, Tony. And look, I credit the defense in this case. They're doing everything they can to create some sort of appellate issue down the road. Because we know that when it comes to these death penalty cases, you're more likely to get it reversed on appeal than actually convincing a jury to return a not guilty verdict and not return a death sentence. Some of these arguments are bordering on frivolous. It's a grand jury. Standard is probable cause. It's not beyond a reasonable doubt. Doesn't matter whether it's prelim or grand jury. The law is clear.
Yep.
The defense, you got their appellate lawyers who are working on the case right now, putting up those legal roadblocks. But this argument has really no legal merit.
It's just the same, more random things coming out of them, seeing what sticks. Is that another one that's being shot off out of their cannon?
Exactly. Swinging for the fences. Because look, you only have to hit once, right? To save Bryan Kohberger's life. So he can fail 9 out of 10 times, 9 out of 100. But one of his legal arguments stick, then you save his life. And that's a win for the defense here.
What's your take on the alibi? And I say that in air quotes, that was not provided, or saying, yeah, we got an alibi. We're just not going to tell you yet. Or we may. I thought some of the verbiage in there was rather interesting, that they may present an argument in cross-examination with expert witnesses. That to me is not really an alibi. The prosecution saying, no, if you're going to argue this, we need to see it now. What is it? And I don't frankly know that they really have one.
No, I don't think they do, Tony. And again, this is, they're overreaching. If there was an alibi witness, we would have heard about it. I know there's a gag order, but this is one of the biggest trials, probably the biggest, maybe this and Trump, in the country right now. So I think that would have leaked by if there was an actual alibi witness. I think the best they can do, like you said, is cross-examine some of the evidence. So I think what they're going to do is attack the cell site evidence. We know that Kohberger's phone did travel from Washington State to Idaho, but obviously it stopped at some point, whether he turned it off or put an airplane mode or just left it somewhere. It was not at the scene of the murders at the time of the murders, right? So that's that. And even if it was, I think the defense is going to attack the syncing of the cell site evidence to some of the video evidence of the white Hyundai Elantra, to say that, listen, this white Hyundai that you've been tracking, Kohberger's phone wasn't in that vehicle, or the timing was off. I think that's going to be the, quote, alibi evidence that they put on, really, to cross-examine the state's evidence. I don't think they're going to have a real affirmative alibi defense, but you never know. I've been surprised before.
Yeah, it's an interesting one of saying he was somewhere else, and we may prove that at some point in time, but there already is strong evidence showing maybe not him at the crime itself at that time, because the phone was conveniently turned off, but it also shows him going that direction, leaving that direction, right around the donut of the crime itself. So to be putting a statement out there of, we're going to be able to say that he was somewhere else at some other time, could they just be shooting themselves in the foot with that as well? Because you'd also then almost have to be arguing someone else had Kohberger's phone going to and from that direction.
Yeah, it's tough with a phone, although we saw this in another case, the YNMW Melly case, where they argue that someone took the phone. And I think it's going to be a lot harder for Kohberger, especially because his phone was pinging near the house the morning after the murders and many other times. It's going to be a tough case, I think, for the defense in terms of attacking the cell phone evidence. But look, you can only play with the hand that you're dealt, and at least they have his phone not at the house at the time of the murder. Of course, the prosecution would say, here's someone that's a PhD in criminal justice. high level of sophistication, understands cell phone and cell site evidence, and that's why he turned it off. But the defense is going to do what it can with the evidence that it has.
How credible and how will the assertion that DNA could have been planted at the crime scene, how will that play with potential jurors in Moscow, Idaho? I think it's one thing if you're to say there's crooked cops in a major city or a place where there's been a lot of issues versus a small town where it seems to be a lot of people more conservative and more very much behind their local law enforcement.
Oh, absolutely. It makes a huge difference. Even here, if I prosecuted a case in Compton, that'd be very different from me prosecuting a case in Torrance, which is a pretty affluent part of Southern California here. Jurors have very strong views of law enforcement, and the whole planting argument is going to be a tough one for them to buy, at least jurors that respect law enforcement and think that they have no reason to lie. The better argument might be that it was transferred. You have a single source of DNA, at least according to what's being reported, right, in that knife sheath. And apparently, there's a lot of other DNA in that house. There were people coming and going. It was a party house. I expect the defense to argue what defense lawyers normally do, right? This was a rush to judgment. You didn't rule out all these other people. There's so much DNA there. And frankly, I would have expected for such a bloody and gruesome crime scene, right? 4 people stabbed, that there would be a lot more DNA than a single source. So I think it'll be a decent argument for the defense, but the whole planting, I don't think it's something the jurors in Idaho are going to buy.
This is an examination of the hidden human condition.
This is the Hidden Killers Podcast.
The Hidden Killers Podcast
with Tony Brueski.